Welcome back to This Week in Immigration. I'm your host, Hannah Tyler. In this episode, we're doing a super-sized segment of The Gavel and discussing the role of the Supreme Court in shaping immigration policy. Specifically, we'll highlight some of the major Supreme Court cases that were adjudicated during this term and how they're affecting the immigration system. BPC regular Theresa Cardinal Brown and Aaron Reichlin-Melnick, Policy Director at the American Immigration Council, will join me to talk through this. We'll also cover DACA in the lower court, focusing on what we might see if DACA is overturned. A great episode to come, so stick around. Welcome back. I'm joined by BPC regular Theresa Cardinal Brown and Aaron Reichlin-Melnick, Policy Director at the American Immigration Council. Welcome, Theresa and Aaron.
Great to be back.
Thank you for having me.
First, I want to talk about how the Supreme Court has taken an increasingly active role in shaping immigration policy in the last few years. Let's start with a broad question. Can you walk us through the history of the Supreme Court making immigration decisions and how far back this goes?
Sure. So the Supreme Court is not new to the area of immigration. And in many ways, immigration cases are some of the most significant ones that the Supreme Court has ever ruled on, including cases that set basic standards about what the 14th Amendment applies to and what kind of protections are available to all people in the United States, regardless of their citizenship or country of origin. Some of the first Supreme Court cases that are really notable on immigration date back to the late 19th century when the federal government began regulating immigration for the first time in large amounts. Prior to the end of the 19th century, most immigration laws were state level, with states restricting who could land and who they would let off the boat, as well as actually creating, in some ways, deportation systems where they would expel certain individuals to either other colonies or back to the countries where they came from. But in the late 19th century, the federal government passed the Chinese Exclusion Acts, and from that era of anti-Chinese sentiment, we got the first major Supreme Court decisions on immigration, and mostly relating to what was now known as plenary power over immigration, and also relating to the individuals who are in the country, primarily Chinese, who are affected by these laws.
Aaron is right. Like it's nothing new to see the Supreme Court weigh in, and some of these laws are like are some of the bases for some of the subsequent decisions we've seen out of the Supreme Court in more recent eras. Things like, as Aaron said, who is protected by the Constitution in the United States? Is it just U.S. citizens? If immigrants are protected, how are they protected? Those matter in various types of immigration decisions, and to what extent immigration law might impinge on rights that might accrue to other people in the United States. And that's a big area for litigation in the Supreme Court.
Yeah, and one of the basic cases in that area, a foundational case, really, is U.S. v. Wong Kim Ark, which is a 19th century Supreme Court case that really affirmed that the 14th Amendment applies to any person born in the United States and that birthright citizenship exists. Wong Kim Ark himself was a person of Chinese descent who came to the United States, who was born in the United States to parents of Chinese who were Chinese immigrants. And when the Chinese Exclusion Act passed, Mr. Ark left the United States, and when he came back, the government tried to block him from entering and said he wasn't a citizen even though he was born in the United States. And he took that case all the way up to the Supreme Court and successfully won, with the Supreme Court confirming that the 14th Amendment gives citizenship to any person who is born in the United States so long as they are subject to the jurisdiction of U.S. law, which generally means that they're not an invading soldier or a foreign diplomat. And since the 19th century, we have seen a number of immigration cases in the 20th century as well, but mostly though we see those in the later half of the 20th century. That's because starting in 1924, the Congress heavily restricted immigration to the United States. And from 1924 to 1965, very few immigrants even came to the United States, and immigration sort of lost a lot of salience as a political issue. So as a result, fewer cases were making it up to the Supreme Court. That said, throughout the last century, there have been really tons of garden variety immigration law cases ones that really are about how to interpret the various immigration laws that are on the books. These are the kinds of cases that no one but the experts really know much about. The practitioners are concerned with them, but they would never make it to a headline, and include cases like, for example, INS versus Cardoza-Fonseca, a decision from a few decades ago that determined what it meant for a person to be persecuted and what exactly is a credible fear of persecution. These are the kind of cases that have enormous implications for immigration law, but that the general public really don't need to know very much about.
Yeah, I would just say that for most of my career in immigration, these were the kinds of cases that you saw get to the Supreme Court. It was, okay, this circuit court decision in California ruled that this interpretation of aggravated felony as applied to this state law was X. And this circuit court over here in, Pennsylvania or New Jersey said that aggravated felony as related to that state law said Y. Supreme Court, figure it out. And they would say, here's what it means. And then every other case related to an aggravated felony and whether or not somebody is deported would cover that. Almost all of these cases were, I would say, deportation related cases. Under what grounds can somebody be deported, as they were rewritten over time between the 1965 Act and later acts, and particularly in 1996, there was a lot of litigation after the laws changed there. But they weren't cases that were about, I'd say, broad-based immigration policy. They were, as you said, like nitty-gritty interpretations of the law and in some kinds the regulations of that law. A few cases related to interpretation of other parts of the law, like standards for legal immigration, but the court review of those kind of cases is much more limited than deportation kind of cases. And for much of my career, as Erin said, when the Supreme Court weighed in, it was like, okay, then we need a tweak to this particular understanding of this particular section of this law that as it applies to this particular kind of case.
Yeah, those kind of cases, you will see 1 to 2 cases like that at the Supreme Court every single term. Just as most fields of law get 1 to 2 cases to the Supreme Court every term. And most of the time, those cases are, again, for the general public, they don't need to know about them. But they're very arcane, exactly. The kind of thing that experts will pore over for years to figure out how to help their clients, but the general public has no need to know them. That said, there have been a number of significant immigration cases, that have come to the court over the last few decades. Ones that the general public probably might want to know about or that have affected broader issues. For example, Plyler v. Doe, which is unfortunately back in the news lately, is a case that established that undocumented immigrants who are children have a right to go to school, and further confirmed that the 14th Amendment applies to them, and universal public education that is granted to any person who resides in a state does apply to undocumented children as well. Similarly, there's cases like United States v. Arizona, the SB 1070 lawsuit, where the Obama administration tried to block Arizona's Show Me Your Papers law. In 2012, that made it to the Supreme Court. And then you do have the occasional case around broader asylum programs, like in 1993, when the Supreme Court upheld the H.W. Bush practice of turning away Haitian refugees at sea without allowing them a chance to seek asylum. That was a case, Sale v. Haitian Centers Council. And so you do every now and then see a big immigration case with large implications on sort of general society at large. But until recently, those cases were few and far between, and the majority of cases that the Supreme Court would hear on immigration in any given year were these sort of practitioner-focused, nitty-gritty expert-type cases.
Yeah, and Erin, just a few episodes ago, we had on Leon Fresco to talk about the implications of the overturning of Roe v. Wade on Plyler v. Doe. So listeners, go back and check out that episode for some really interesting conversation.
So would you say that there's sort of been a pattern in recent years of the Supreme Court making these sort of more broad-based immigration decisions, or is that sort of still being borne out?
I think it's always important to keep in mind that the Supreme Court only hears cases that make their way to the Supreme Court. And so today, I would say immigration has always been volatile and political. It was a major political fight in the 19th century. It was a major political fight in the early 20th century, in the mid 20th century, the late 20th century, and now the early 21st century. But what has changed is that we are seeing a lot more cases about executive policy. As Congress has essentially abdicated its role in actually setting any immigration law and creating new laws, we are seeing states start trying to pass their own laws, and we are seeing the executive branch acting a lot with a lot freer hand to set immigration policy in ways that it hasn't in the past. And I think DACA is the example that most people think about when they consider that. So what we are seeing as a result is more of these cases being brought and more of them making it up to the Supreme Court, in part because they are cases about executive policy. And it's a lot easier to challenge executive policy in court and make it to the Supreme Court than it is to challenge a law passed by Congress, since that is inherently a lot harder to challenge because you could only challenge it on the basis of being unconstitutional. Whereas with all of these policy issues, you can challenge them on the basis of not only being unconstitutional, but also violating a law passed by Congress.
I would add that other areas of law outside of immigration have probably seen more of these kind of broad-based executive cases. I think of environmental law and labor law, areas that have had large histories of case law interpreting or saying whether or not the administration has gone beyond its statutory authority in certain respects. Obviously, there was a recent Supreme Court case about EPA regulations, but the EPA has been sued an awful lot in its relatively short history as a federal government agency over its regulation stemming from only a small number of statutory actions. So that gives you a sense of, immigration law has been around for many, many years longer than, say, the Clean Air Act. And yet, the fact that we're seeing many more of these kind of executive action decisions now just gives sort of credence to what was said before, is that most of the previous decisions were based on statutory interpretations.
And are there sort of specific types of cases that the Supreme Court is agreeing to hear over others?
So we already talked about this a little bit, in response to the last question, because we are seeing, like in every year, the Supreme Court continue to decide practitioner-focused immigration cases. This term, there were several of those cases. Last term, there were several of those cases. But people certainly have the sense that the Supreme Court is deciding more of these bigger political questions. And I do think that is more to do with the fact that we are seeing more uses of immigration policy from the executive that are then vulnerable to lawsuit and being brought all the way to the Supreme Court.
Okay, so now that we've talked about the Supreme Court how they're generally approaching immigration decisions, I want to move on to a few specific cases. So in the last few years, we've seen a lot of large immigration decisions come out of the Supreme Court. Erin, you've talked about sort of a lot of cases. What, in your opinion, has been sort of the most consequential immigration decision the Supreme Court has made?
When we talk about consequential, I think there's really two ways in which we can talk about it, because there's consequential to people and to the individual immigrants and their families and their loved ones who are affected by these decisions. And then there's consequential when it comes to the development of legal doctrine, which will establish, future limits on what the executive branch or the courts can do. So when it comes to consequential, the most consequential case for people's lives, it's actually the administrative law case of the DACA decision, because that was not actually an immigration law case. That was a garden variety case about administrative law and what steps a presidential administration has to do to properly rescind a policy put forward by their predecessor. And nevertheless, that saved the DACA program, and that saved over 600,000 people who had work authorization and permission to reside legally in the United States through the DACA program. So certainly in terms of lives saved, it would have to be the DACA decision. The corollary, though, is decisions that have gone against immigrants, and I think the most consequential there, which is an actual immigration law decision, was Trump v. Hawaii, the case about the president's travel ban. There, President Trump really created a travel ban with no historical analog. No president had ever attempted to use the authority granted to him to suspend the entry of certain individuals anywhere near as sweeping a manner as President Trump did to turn away thousands of immigrants from countries that he effectively determined were, unreliable in sharing security, but realistically that we know were because they were primarily Muslim. And that decision really entrenched a much broader view of presidential policy to turn away immigrants and rejected some kinds of restrictions on those authorities. So not only was it consequential because it meant thousands of people were not able to legally immigrate to the United States who otherwise qualified for visas, keeping families apart, it also reinforced this harsh view of immigration law. And then I want to throw one other out there because you can't ask me what the most consequential was and me not give you three different cases. I think the sleeper here is a case called DHS versus Theresa, which I think I'm pronouncing correctly. This was a case decided 2 years ago that concerned what rights do asylum seekers who are newly arriving on U.S. soil have. Can they go to a federal court and say, my rights have been violated? I have a right to go through an asylum process, and I would like to vindicate that right in court before you throw me out of the country and potentially send me back to my persecutors. And in a decision written by Justice Alito, what the Supreme Court essentially said was, you don't have any rights. Congress got rid of all of your rights. You are newly arrived on this country. It doesn't matter that you're on U.S. soil. You are simply outside of the Constitution. And if Congress wants to throw you out, it's entirely within their right to do so. And you can't even go to court and ask for a writ of habeas corpus. The federal courts are essentially locked out for you because Congress said so. This has really started what I, over the last few years, has seen as a chipping away of the right of immigrants to go to court to make sure that their rights are respected. And since that term, we have seen the Supreme Court steadily erode judicial review on behalf of immigrants and slowly but surely enforce a set of laws passed in 1996, which were designed to keep immigrants out of the federal courts. So when it comes to the development of legal doctrine and longer-term impact on immigrants, I think Theresa really heralded the start of the current conservative majority's attempt to crack down on judicial review for immigrants by harshly enforcing a 1996 law where Congress stripped federal courts of their authority to hear a lot of these cases. And we saw that this term as well with Garland v. Gonzalez, the latest Biden v. Texas, the Remain in Mexico decision. But really, I think a lot of the roots of that current shift away from judicial review and in favor of stripping federal courts of these authorities in Theresa.
The one thing I might just add, Aaron, and I'd welcome your thoughts on this, is in U.S. v. Arizona or Arizona v. U.S., right? The U.S. government was suing the state of Arizona over state laws that essentially the court eventually ruled stepped on the federal government's primacy on immigration law. They were essentially duplicative of federal immigration law, and therefore they didn't have the power to do that. That was a decision against a state about a state action. But Trump versus Hawaii was a state suing the federal government over an immigration action it took. And that throws me back to the DACA decisions in district court, which we'll talk about in a minute. But that case and others like it are what I see is kind of fairly different right now, where the plaintiffs are states rather than an individual immigrant or a class of immigrants, or even an organization that has a vested interest in the immigrants. For example, the Regents of the state of California was one of the DACA, the previous DACA decision that made it to the Supreme Court. This is the state of Hawaii and other states, and we've seen that as well. Do you see a difference in how the Supreme Court treats those kinds of cases? Because there's another issue at play there, and that is their standing to bring the case, right?
Yeah, and I think if you look back to Arizona v. U.S., that is also another one of the incredibly consequential decisions that have been issued in the last decade. when it comes to state suing, that is a major shift. We didn't used to see this before. If you look at the old immigration law cases, even ones that decided questions of state law were usually brought by private plaintiffs or were brought by the United States on behalf of essentially the federal government's interests in maintaining its authority. When Judge Hainan ruled and blocked the Obama administration from carrying out DAPA, which was Deferred Action for Parental Accountability, which is for the parents of kids with DACA, and blocked both DAPA and extended DACA, which would have expanded DACA to a broader pool of people. That was really the first, what we've seen, of a state essentially invoking really minor garden variety costs imposed by immigrants to get standing to sue and block a federal policy. And unfortunately, the Supreme Court and the Fifth Circuit have largely blessed these going forward, which is why under the Trump administration, you had everything from Cook County, Illinois, to the city of San Francisco, to states suing to block Trump administration policies on the ground that they essentially affected the people within their states, or caused the state some sort of injury by reducing tax inflows or other forms of revenue that the state was going to gain. And so with the Supreme Court not only not in any way blocking these decisions, but essentially validating them and allowing them to go forward, we have really seen a relaxation of standing doctrine for these states and counties that are suing. And we've also seen, as a result of this, the states who are challenging these cases getting enormously sloppy. In some of the lawsuits brought by Texas and others against the Biden administration, their arguments are incredibly attenuated. They're making arguments like, if this policy goes into effect, then an ICE immigration officer may choose to release someone from a detention center, and that person may go out and move to my state and commit a crime and therefore will impose some costs on me. You get these really attenuated chain of logic, and they're not even attempting to prove anything anymore. They're simply asserting that they are being injured by these policies. And we're seeing the judges in Texas and Louisiana essentially say, yeah, that sounds about right, without ever actually making them go through any effort to prove that they are negatively impacted in some way by a particular policy change.
Yeah, we'll see how that plays out as we talk about other cases.
So speaking of specific cases, you mentioned Garland v. Gonzalez. Can you sort of explain the significance of the case and how this case will affect immigration policy moving forward?
Yeah, so Garland v. Gonzalez is a case that was decided a few weeks ago that came out of a series of class action injunctions that were sought by detained individuals and their advocates against ICE, trying to get ICE and the immigration court system to relax the standards for release. And to just say, as the background there, unlike in pretty much any other system in the United States, when the government detains an immigrant, they don't have to prove that that person should be detained. The Supreme Court has blessed mandatory detention for immigrants. And what that means is that, it is up to the federal government to lock you up. And then at that point, they essentially don't have to prove that they have a reason to do it. They just say, Congress, let us do this. That's very different, for example, if you're involuntarily confined on psychological grounds. You can go to a court at any point to challenge that, and they have to prove, it's the government that has to prove that you're the one who should be locked up. But when it comes to immigrants, even the ones who are not held in mandatory detention, the immigrant has to prove that they are the ones who should be released. It's the immigrant's burden to say that I am not a flight risk, I am not a danger to the community, why are you detaining me? That's very different than pretty much any other area of law, criminal or civil commitment law. So some advocates through class actions challenged a number of these policies, and including, whether or not individuals should be held in detention, without a right to a bond, what should be the standard. And they got a number of positive decisions in their favor. When the case made it up to the Supreme Court, there was a question, however, and that question was, what is the impact of a 1996 law that says as follows? It says, no court other than the Supreme Court shall have the jurisdiction to, quote, enjoin or restrain the operation of several immigration enforcement laws, and specifically the laws relating to arrest, detention, removal proceedings, and deportation. So what does it mean for a court for the law to say no court has jurisdiction to enjoin or restrain the operation of these laws? Well, for the first 25 years of these laws being passed, courts generally interpreted that to mean that you couldn't get the administration, you couldn't get a court order forcing the government to go beyond what was required in the law. But you could get a court order to force the government to follow the law, with courts both, conservative and liberal and judges across the political spectrum ruling that, when you are enjoining or restraining the operation of a certain law, if all you're seeking is for the federal government to follow the law, you're not getting them to be restrained from the law. You want them to follow the law. You don't want to enjoin them or restrain them at all. You just want to restore the federal government back to a position where it is not violating the law. And so courts allowed those lawsuits to go forward. But in Garland v. Gonzalez, a decision written by Justice Alito, again, what he said was actually no, that's not true. Because when the federal government is unlawfully operating a law, it is still operating the law, just in violation of the law. And a court telling the federal government to follow the law is restraining or enjoining the unlawful operation of immigration enforcement laws. Now, if you think to yourself, this makes absolutely no sense, what are they talking about? That's how a lot of us, thought when we read this decision. But the upshot is that essentially the Supreme Court has stripped federal courts of their ability to enter injunctions relating to most immigration enforcement laws. And again, specifically, the laws relating to arrest, detention, removal proceedings, and deportation. So this decision does not affect, for example, a lawsuit about a USCIS work permit regulation, about, giving employment authorization to various immigrants. The restrictions do not cover that. But this essentially means that federal courts have their hands tied and are not able to enter relief, enjoining or restraining even illegal policies relating to immigration enforcement. That said, that doesn't mean that there will be no way to challenge unlawful and illegal immigration enforcement policies. There's still a couple of remaining questions out there. Like, for example, when a federal court vacates a policy under the Administrative Procedure Act, does that count as enjoining or restraining it? Because so far, every single case to decide this issue has been about an injunction, a court order requiring the government to do something. But what about simply when a court says, this policy that you put forward violates the law and should be set aside? Does that count as enjoining or restraining? That is a huge question that has yet to be decided and will significantly impact the Biden administration's ability to put forward its own policies. But it also, importantly, this also affects future immigration enforcement policies and future presidents. And it may mean, for example, that a lot of the court decisions blocking Trump administration policies were invalid. And it's really going to reshape how immigration litigation goes forward. If you can't get a court to step in on an early basis to restrict an unlawful policy, does it essentially mean that you have to let this policy stay in effect for months or years while the case wends its way through the court? It might. And that's not good for sort of the rule of law in general, even though currently during the Biden administration, that may be positive for some immigrants.
Yeah. I mean, the immediate case that I think of that has impact, that Garland v. Gonzalez is likely to impact, is the cases making their way through the circuit courts right now over the Biden administration's enforcement memorandum, the ICE enforcement memos, because those are instructions about when you can arrest somebody or detain them, including the executive order about prosecutorial discretion in immigration courts. Do you think that this has direct relevance to those memos in those cases?
Absolutely. And the issue has already come up. When Garland v. Gonzalez was decided, the Department of Justice went back to Judge Tipton, who had a few days earlier blocked vacating. He had vacated under the Administrative Procedure Act Secretary Mayorkas's enforcement priorities. And the DOJ went back to him and said, look, you just got this decision from the Supreme Court saying you cannot do that. You cannot enjoin or restrain the operation of immigration enforcement laws. Judge Tipton responded saying, I don't read it that way. I think this is only about injunctions, that this law does not apply to vacating a policy, and therefore I'm just going to say it's irrelevant. But that's making its way back up to the Fifth Circuit. And certainly the Department of Justice strongly believes that it does apply in that circumstance. And they have a pretty strong argument that a court order essentially restraining Secretary Mayorkas from enforcing immigration enforcement laws the way he wants is in fact a court order enjoining or restraining the operation of the relevant laws and therefore barred.
In other words, whether you call it a vacate or an injunction, it has the same effect.
Yeah, that's what the DOJ is arguing. And unfortunately, we're in the area that no one wants to be as a lawyer, of pure semantics. And there's going to be years of fights over what the word enjoin mean, what the word restrain means, what the operation of means. And indeed, even in the DACA case, we might get a question of what it means to be, to enjoin the operation of enforcement priorities, which are sort of not specifically mentioned in statute, some of these. DACA relies on sort of residual authority inherent in the enforcement process and prosecutorial discretion, but that's not written anywhere in the statute. But that said, is enjoining or restraining that, restraining the operation of immigration enforcement laws, even though that authority is not specifically mentioned in the enforcement laws? That's a good question, and that's something that a lot of lawyers are going to spend a lot of time arguing.
Okay, so let's move on to the real blockbuster. Last week, the court also handed down a decision on Biden v. Texas, the case involving MPP, migrant protection protocols, also known as Remain in Mexico. The court ruled in favor of the Biden administration and paved a path for the Biden administration to terminate MPP. So, Aaron, can you talk about the case's path to the Supreme Court and sort of how we got here?
Yeah, to understand the path to the Supreme Court, you really have to go back to the original the original Remain in Mexico program. In 2019, the Trump administration created the so-called migrant protection protocols, also known as Remain in Mexico, and sent over the course of a year and a half about 70,000 people back to Mexico, though the exact numbers remain unclear. The program was immediately caught up in litigation, and the Ninth Circuit eventually ruled that the policy was in fact unlawful and ordered the Trump administration to stop using it. And that was in 2020, but what happened very quickly there is that the Supreme Court stepped in and overruled the Ninth Circuit's order and said, we're going to let this continue until it makes its way to the Supreme Court. And the Supreme Court was set to hear oral arguments on the legality of the Remain in Mexico program in spring of 2021. But when President Biden took office, he initially said, we don't want the Supreme Court to hear this case. And he suspended the program and essentially got the Solicitor General to have that case dismissed from the Supreme Court's docket. So as of today, the Supreme Court has still not ever ruled on the legality of the Remain in Mexico program. But what happened was Texas, along with Missouri, sued the Biden administration for getting rid of the Remain in Mexico program, arguing that it had set off the border crisis. To be clear, there is no evidence for that. By the time Biden took office, the Remain in Mexico program was almost vestigial. It was only being used on about 1,000 people a month, if that, because the majority of people were being subject to Title 42. And even court hearings under Remain in Mexico had been suspended since March of 2020, long before President Biden took office, and Mexico was really mainly dealing with Title 42 and not Remain in Mexico. So the idea that Biden setting aside this program really did much of anything is not supported by the evidence, despite what the challengers put forward in that case. So Texas sued, won, got a court order saying, of all things, that it's not that the Biden administration went through the wrong procedure to end the Remain in Mexico program. They got a court order saying that, but also the court said they can't end the Remain in Mexico program ever. And what Judge Kaczmarek's decision said was really wild. He said that a 1996 law essentially required every presidential administration ever to send people back to Mexico under the Remain in Mexico program or some version of it, so long as they could not detain every single person crossing the border. Now, that has never been possible, ever.
Well, it's also never been implemented this way. And Aaron, I appreciate you raising this because, one, we'll get to the Supreme Court decision on this, but this just made me, from my days at DHS, crazy when I read this. Because I worked at DHS under the Bush administration, under the Obama administration, and this was never even considered a possibility. This provision of law that allowed somebody to wait out their immigration court case on the other side of the land border, because it was only applied to land borders, was predominantly used as a convenience to Canadian citizens who would prefer to wait in Canada for their immigration dates in the United States. So maybe a handful of people a year this applied to. I don't recall it ever being applied anywhere in Mexico. So it definitely went beyond what anybody had interpreted before. But also, just based on what you said, it was the exact inverse of what the Ninth Circuit had ruled previously, correct?
Yeah, well, interestingly enough, because this was a lawsuit brought by Texas, Judge Kaczmarek in Texas didn't even have to rule on whether he thought the program was legal. He simply said, he sort of presupposed the legality of the program, ignoring what the Ninth Circuit had said and simply saying, well, I disagree, I think it's legal. And then said, so this program created in 2019, not only did the Biden administration, in his words, go about the wrong way to end it, but they could never end it until Congress builds, thousands of new detention centers to lock up every single person crossing the border. At that point, then a presidential administration could end it. It had also meant that, under this interpretation, even the Trump administration was violating the law when they created the program because MPP did not apply to everybody. Mexicans could not be returned to Mexico because that would be a violation of international law if they were seeking asylum. And so, but under Judge Kaczmarek's, interpretation of this, even that was unlawful, that they had to send people back to Mexico, even though it violated a totally different law. And so that, on the basis of this extremely bizarre interpretation, it was appealed very quickly up to the Supreme Court for an emergency relief. And in a pretty stunning decision in September of 2021, the Supreme Court said, we actually agree. We're not going to step in, but they said we agree only on the grounds that we think that the policy memo, which Secretary Mayorkas put out in June 2021, terminating the program, was not valid. And they cited the DACA case for that.
So Administrative Procedure Act violation.
Yeah. And they did not say anything about this argument that MPP was required. But nevertheless, they let this court order go into effect and forced the Biden administration to go to the negotiating table with a foreign nation, Mexico, and ask for permission to restart the program. And in December of 2021, that permission was granted. Meanwhile, in October of 2021, Secretary Mayorkas issued a new memo saying, all right, we admit it, the Supreme Court said it, we went about it the wrong way back in June. So what we're going to do is we're going to say, all right, you win. That June memo, gone. We totally accept it was inappropriate. It didn't follow the right procedures. So here's what we do. We've gone back to the drawing board and we are making a new decision based on totally different facts. This time we've done a far more comprehensive review. We've talked to dozens of people. We've considered all the relevant factors, and we are still coming to the same decision. We want the program to end. What happened then, that it was decided, that memo came out 2 days before oral argument at the Fifth Circuit. Notably, the Department of Justice had told the Fifth Circuit that they were going to issue a new memo and had said, hey, we are going to be issuing a new memo. Can you hold off on having oral argument and send this case back to the lower court? Because at this point, we think this new memo is going to override the concerns. Because the case that was being argued at the Fifth Circuit was about the June memo, the one that the Department of Homeland Security had just said, we give up, we accept it was not appropriate. The Fifth Circuit was very unhappy about having been asked that and issued a scathing, nasty decision attacking the government for trying to appeal the June memo that had been struck down while simultaneously issuing a new memo to get rid of it. The decision is notable really for how nasty it is. It essentially accuses the government of bad faith, says they're trying to put one over the Fifth Circuit. It's really not a pleasant decision to read. And so what they eventually said as a Fifth Circuit was, not only do we agree that this program is required by law and you're not allowed to end it, but also we're just going to ignore the October memo entirely. We just think it is irrelevant. It was, after the fact justification. We just don't intend to give it any legal import whatsoever. Screw you, is how I would say the Fifth Circuit decision was.
Without those exact words.
Yeah, but not pretty close. I mean, seriously, the Fifth Circuit decision is notable for how angry the judges seemed. Yeah. And so then what happened? The Department of Justice then went to the Supreme Court really quickly, within a matter of weeks, and said, look, it's already December. You need to hear this case ASAP because we need to have a decision this term before the end of this year and not wait until 2023 for a decision. And so they went to the Supreme Court on two questions. One, whether or not Judge Kaczmarek and the Fifth Circuit were right that every single administration since 1996 had violated the law and that this program is required and can never be ended. And two, whether the Fifth Circuit was right to essentially ignore their second attempt to end the program. And what we eventually got was a decision saying, no, quite obviously not. The program can be terminated by a new president. And they use this because it's not even a difficult question. And, I don't usually like to go into the law here, but this one's a pretty easy one. One provision of the law says everyone who crosses the border shall be taken into custody. And the other says some people taken into custody may be sent to Mexico. At the lower courts, in front of Texas won on the argument that if you shall detain everybody, then you may detain them. That doesn't really make any sense. And what Justice Roberts said was, may means may. The law says you may send people to Mexico, and that doesn't mean at any point that you are required to send people to Mexico. It says you may do it, but you don't have to. That was a pretty easy and 6-3 decision in that question.
So what's fascinating to me about this decision, and that may means may, is that in other rulings in other cases, particularly court decisions about ICE detainers, courts have said that shall can also mean may.
Interestingly, the Supreme Court decided they didn't want to rule on that. And it's important because shall often means may, because here's a good example of this. The law says every person who, violates, for example, every person who is found with drugs shall be arrested. That's a great example of the law. But the federal government cannot arrest everybody. And sometimes you come across somebody who has drugs that you don't want to arrest. Heck, maybe they're a confidential informant and you're going to recruit them to your cause and you don't want to arrest them and charge them with an offense. And so the federal government, any criminal, any or federal, state, and local criminal authorities have always been able to disregard mandatory language about arrest because of prosecutorial discretion. You can always choose not to arrest someone. But that's different from what the states were trying to do, is take a may and turn it into a shall.
A shall.
Versus what the Department of Justice was saying is that this shall means may. And the Supreme Court explicitly did not rule on this question because they said we don't even have to rule on that because may means may. It's just as simple as that. And when it came to the Fifth Circuit, on that question there was really no debate, 6-3 as well. That essentially the Fifth Circuit was just totally wrong. What the Department of Homeland Security did in issuing the October memo was perfectly normal, acceptable, nothing particularly strange about it. All of the Fifth Circuit storm and drang over that. It was just ridiculous. I will note the decision was technically 5-4, but Justice Barrett wrote separately saying she agreed with the merits of the decision. She just thought that they shouldn't have heard the case in the first place, citing Garland v. Gonzalez and saying, we think that this case should have just been remanded back to the lower courts to apply Garland v. Gonzalez to decide whether or not this injunction was valid in the first place. Because in the Biden v. Texas decision, the Justice Roberts said that injunction ordering them to restart the program was totally invalid under Garland v. Gonzalez and should never have been entered in the first place. So Justice Barrett and Justice Alito both thought That is not a question that the Supreme Court should have answered at this point because it was not raised initially. It was only came up sort of after oral arguments. And they just thought that procedurally, that's just a question that should have been sent back to the Fifth Circuit to answer in the first place, rather than the Supreme Court answering.
So can you talk a little bit about what this means for the Remain in Mexico program practically?
It means an end to the program, and sooner rather than later. The October 2021 memo signed by Secretary Mayorkas says it goes into effect the minute the injunction ordering them to restart the program is vacated. And that's going to happen as soon as the mandate is issued in the Supreme Court case and the case is sent back to the lower courts. So that is just as a matter of like appellate procedure, takes a few weeks. And so as of today, the week after the decision, it is still in effect and will continue for several weeks until the sort of proper legal procedures have gone in place and the decision takes effect. But as soon as the decision takes effect, Remain in Mexico is over.
Theresa, can you talk a little bit about what this decision means for our relationship with sending countries and our foreign policy?
Yeah, that was an interesting part. During the oral arguments of this case before the Supreme Court, many of the judges, both conservative and liberal judges, remarked that the injunction mandated the federal government, the Biden administration, take a specific foreign policy action, that is, negotiate with Mexico on the restart of the MPP program. And that essentially meant that the Biden administration, in order to meet the requirements of this injunction, was at the mercy of Mexico. Whatever Mexico required to restart the program, the United States government essentially would have had to give it, immigration related or not. Now, we don't know what all went on in those negotiating rooms. We do know that when MPP was restarted, Mexico had certain conditions related to which nationalities, related to who would be exempted and not put into MPP. So they came with demands, and those demands for the most part were met. And in the oral arguments, many of the justices said, hey, wait a minute. The courts have traditionally had a very, very hands-off approach on anything that sniffed of foreign policy, because constitutionally foreign policy is the exclusive purview of the executive branch. Now, that doesn't mean that Congress can't pass particular laws that may, eventually affect foreign policy. Obviously, Congress has the power to declare war and authorize aggressive actions. But this was a direct foreign policy requirement. We had to go negotiate with another country for a specific outcome. And that is almost never the case. And courts had never previously done this. So one of the aspects of the Supreme Court ruling was a statement, although this wasn't a point that was reached because they didn't have to, because as Aaron said, may meant may. But they also were very clear in the majority opinion that that requirement also cast doubt on this idea that a lower court could order the government to engage in a negotiation of this type. And so I do think that the Supreme Court's decision in this case preserves the U.S. government's ability to negotiate with foreign governments in many different ways that may benefit us on our immigration policies. And I would note that, for example, the Los Angeles Declaration, which isn't binding, but is an international instrument with commitments that were made by various countries on immigration, could not, might have been also subject to some sort of litigation over it. And so I do think that the decision is notable in that respect. I think that was one of the things that many of us also noted when that injunction first came down and the Fifth Circuit upheld it, was that, never before had we seen a court mandate this kind of requirement. I think I said even on this podcast when it came down, well, the Biden administration could get out of this if Mexico simply said no. If Mexico has said, no, we will not do this, then the Biden administration could have gone back to the court and said, we tried to implement it, but Mexico said no. And then what would happen, I'm not sure. But I'm glad we didn't get there. And the Supreme Court has said that we don't have to engage in that kind of a negotiation.
Interestingly, I will note, Texas actually tried to get the Judge Kaczmarek to rule that Mexico didn't have to comply. That this was essentially Texas went to them, in the early weeks and months of the Department of Homeland Security negotiating the deal to restart the program. Texas got impatient and went to the lower court and said, look, even if they don't restart it in everywhere on the border, they can start taking people who are arriving at ports of entry and sending them back to Mexico. What Judge Kaczmarek says, look, that's ridiculous. Even he was not willing to say that Mexico didn't have the ultimate say so.
That in order to protect our sovereignty, we must violate another country's sovereignty is essentially what that would mean.
Yeah, and even Judge Kaczmarek said, obviously, that's not the case. So despite Texas trying to get it, and I will say this is partially because Texas seemed to have a really bizarre understanding of how borders work. They seem to suggest, and the Fifth Circuit kind of suggested this as well, they thought that, people were being sent back to Mexico who were just walking up to ports of entry. That's not the case. You don't get processed to be put into the Remain in Mexico program unless you have made it onto U.S. soil and can be returned to Mexico. And I think that was partially a problem to do with the name Remain in Mexico, which suggests that people never left. But Remain in Mexico was actually returned to Mexico, and you had to be on U.S. soil in order to be returned to Mexico. And so Texas's kind of bizarre assertion that people, didn't have to be on U.S. soil and return to Mexico in order to be put into the program was just laughable and really exposed how little they actually understood about the practical operation of the program.
Speaking of lower courts, they have also been very active in taking up immigration cases, and one high-profile case currently scheduled in a circuit court of appeals is the DACA case. The Fifth Circuit heard oral arguments on the case today, actually, July 6th. DACA has been on shaky ground for several years, really, since its creation, given that litigation over the program has been pending for most of its existence, and Congress hasn't codified it into law. So, broad question, can you talk about the way that cases proceed in federal court from the district courts to the appeals courts and back? And are we seeing more federal litigation on immigration in these district and circuit courts these days?
I feel like I should have, given this overview at the start of the podcast, but, for people who aren't lawyers, how cases make their way through the court system is not something that a lot of people know. So what happens in these cases is that people file a lawsuit in federal district court. There are a large number of federal district courts around the country, divided into a set of districts. Each district sits within a circuit, and there are 11, and there's actually more than 11 federal circuits, but mostly what you need to know about are the primary 12 circuit courts. The 1st through the 11th Circuit and the D.C. Circuit Court of Appeals. There's also the Federal Circuit, which makes 13. But basically speaking, once a case is heard in district court, the district court judge issues a decision because it is a trial court. Once the trial court issues a decision, it can be appealed first to the Federal Circuit Court. Then the Circuit Court issues a decision upholding or overturning the lower trial court decision, and then that can be appealed up to the Supreme Court. One key difference on appeals between circuit courts and the Supreme Court is that the Supreme Court doesn't have to hear cases. The circuit courts do. If you lose and you want to appeal in a federal from a federal district court decision, the circuit court has to hear your case. They can't decide not to hear it. We are seeing a lot more immigration cases. That really has been growing since United States v. Texas with the original DACA-DAPA decision in 2014. With Judge Hainan, and since then under the Trump administration, there was an explosion of lawsuits brought against Trump immigration policies, and now we are seeing a similar explosion of lawsuits brought against Biden administration policies, and there are a number of them pending in the lower courts right now.
Yeah, I think we talk about it very often that as soon as any administration issues any immigration policy, we sort of do a countdown of how many hours or days till the first lawsuit is filed.
So for this case specifically, for the DACA case, what should we expect from the Fifth Circuit on this decision? Is there sort of any indication as to how they might rule?
Yeah, oral arguments today, I would say, largely suggested that the Fifth Circuit is going to do what it has done before, which is strike down the legality of a DACA program. In the past, they only struck down the legality of expanded DACA and DAPA, but it seems pretty likely from oral argument today that they are also going to rule against the Biden administration again on DACA. And it's in part because the Fifth Circuit panel that they drew was very, very conservative, including 2 Trump appointees, including Judge Ho, who was one of the most conservative appointees to the Fifth Circuit of all of them. And so as a result, we are not expecting a decision in their favor. That said, the wild card here is Garland v. Gonzalez, what we were talking about before. Does this injunction against the DACA program count as a forbidden restraint on the operation of the immigration enforcement statutes? That is a question that some challengers, the defendant interveners, who were some of the DACA recipients themselves, raised to the Fifth Circuit and said, look, we think this case should go back to Judge Hainan for him to decide in the first place whether or not he is even allowed to issue this order. So that is about the only wild card right now, but I don't think people really should be expecting anything majorly positive. The Fifth Circuit has already struck down a version of DACA once, and it is likely to do so again.
So if they rule against DACA, practically, what does that mean? Does the program go away? Is there a chance that it goes up to the Supreme Court, that it goes back to the Fifth Circuit, like you said, in the wild card? What happens?
So almost certainly the case goes up to the Supreme Court, and very likely the decision does not go into effect during that time. And so I think until this thing makes it all the way back up to the Supreme Court again, we will not have a decision that actually gets rid of DACA. And so we are going to once again be back at the Supreme Court, quite possibly next year, for a June 2023 decision on whether or not 600,000 DACA recipients are going to lose their status. This is, a really unfortunate place to be because, the Supreme Court, which just has tried to wash its hands of these immigration cases, maybe it's going to decide it wants to wash its hands of that case and decide, hey, this never should have been, this is an injunction that never should have been issued in the first place. And maybe they find a way to punt on it. But ultimately, this is almost certainly making it back to the Supreme Court unless Congress steps in and does something. There have been many thoughts that, if they get rid of DACA, then Congress maybe is finally going to get its act together and do something. I'm optimistic that they can do something, but I'm not that optimistic to think that it is highly likely at the very least.
You're not laying your money on the odds right now.
I would hope that Congress is not dysfunctional enough to let 600,000 people lose their jobs and their status and risk deportation. That said, I'm also a realist, and I understand that there are a lot of contingencies that we don't know, including who's even in control of Congress when that maybe happens.
Yeah, I think it's worth noting a couple of things. Like I agree that whatever decision the Fifth Circuit comes out with, even if they uphold the district court decision, they may allow the program to continue while it's appealed to the Supreme Court, primarily because Judge Hainan, when he issued his decision, more than a year ago, stayed it. He stayed that decision. He stayed his own decision and said, I'll let this be appealed, because he recognized, I think, that it's, one, nationally politically volatile, and two, there's a lot of dependence interests here. It's also worth mentioning that DACA survived its last trip to the Supreme Court only because there was a vacancy on the court. The decision was 4-4, which is essentially a no decision. In other words, if there is not a majority, then by default, the underlying decision remains in place. And in that case, it was to kind of keep it going for the time being. So I think that is, that's the position that we're in. I think there are a lot of people looking at the super majority of conservatives on the court now with skepticism over how they would rule should it come up to them. I think that there were many people, including some folks from the Bipartisan Policy Center, to be fully transparent, when the Obama administration issued the DACA program, who felt that he exceeded his legal authority. There's a difference between whether or not you believe a policy is a good policy and whether or not they have the authority to enact it. And I think, our task force at the time made that statement very clear. We think the policy is a good policy and that Dreamers should be protected. Ultimately, it's Congress that should do it. And the statement we issued about that said the same thing. What Aaron said at the beginning of this program, I think is so true. All of this litigation that we continually talk about on this podcast, that we even named a segment after the gavel, is predominantly being produced because of lack of congressional action on immigration policy. And I don't really care wherever you fall on the idea of what immigration policy should be. I hope that we might agree that having the courts be the decider of this much of our immigration policy, not these fine areas of how you interpret a law in a given case, but broad swaths of how immigration policy should be implemented. This is not what courts should be engaged in, because they are in the middle of very politically volatile fights that should be decided by the political branches of government, the administration and Congress working together to figure out what can be done. And so if after all of this, I hope folks listening to this will understand why it's so important that we get Congress to do its job on immigration and not keep punting it to somebody else to fix. Keep punting it to the courts, keep punting it to the states, keep hoping the Supreme Court will weigh in, whichever side you're on. Like this, we've got to get back to the place where we're deciding immigration policy by a much more consensus-driven policy, I think.
Yeah, it's been 36 years since we last had any large-scale regularization of undocumented immigrants in the United States. It's been 32 years since we last amended in any major way our legal immigration system. And it's been 25 years since we last passed any immigration enforcement laws, including changes to the asylum system. The last time Congress updated the legal immigration system was November 1990, a month before Tim Berners-Lee put the very first website online. The World Wide Web, in essence, did not exist when Congress last passed a change to our legal immigration system. And so did the Soviet Union did exist. So we are really using these antiquated late 20th century laws to apply to a modern 21st century situation. And the reality is that, in fact, much of the heightened enforcement policies adopted in those laws in the late 90s are why we have such a large undocumented immigrant population in the first place. Because one of the things Congress did back then was basically say that if you had ever entered the country undocumented, then you would essentially be barred from any kind of immigration relief ever if you left the country. And so what this created the situation was, as they walled up the borders and made it harder for people to get in, was that all the 11 million who were here basically said, shoot, I guess we can't ever leave, because if we ever leave, we're never going to be able to get back in. And so that led to the situation now where we have, still millions of undocumented immigrants. At this point, hundreds of thousands of them protected under various temporary statuses, 1.8 million people in immigration court. The reality is you're never going to resolve these issues through purely executive action. You need Congress to do something. But since 2013, Congress has essentially abdicated any real chance to do something.
I will add that if the 96 laws are responsible for a lot of the undocumented that are here, the fact that we haven't updated our 1990 laws is one of the reasons why we are having so much issues at our border right now. Because for many, many people who would want to come to the United States legally, there is no temporary visa that they could use, or no permanent visa that they could use, or the backlogs are so great that they would never have a chance to get in. That we have asylum laws that we can't actually implement because we have backlogs in our asylum system. So it all boils back to, as Aaron said, making me feel very old, how old our immigration laws are, because I started way back when those laws were new. And now they are very old. And that tells you how old I am. But I firmly believe that that's the biggest argument about why we need to update the whole system, every piece of it. It's not enough just to legalize everybody now. Unless we fix the problem, we're going to have more people coming, as they have been trying for a long time. We need to address all the parts of the system. And we can't just keep, again, punting it to executive branch or thinking we can piecemeal little bits of it. That's not gonna fix anything.
Yeah, and I'll note as a final point to agree with all of this that Congress used to do this more often. In the 20th century, Congress generally tended to upgrade immigration laws about once every decade, once every 2 decades or so. You got major immigration laws in 1917, 1924, 1952, 1965, 1986, and then 1988, 1990, 1996. And then since then, we essentially just stopped. The last, we've had a couple of minor tweaks here and there, but really since 1996, there just hasn't been anything major else. And I think that is a major shift. And it has really led to this metastasis of immigration policy, which has created the executive branch's sort of rationale for doing all of these things. And so, until we actually fix this, we're not going to solve any of the problems. We're just going to be encouraging more executive branch intrusion, onto what has traditionally been viewed as a congressional prerogative. And you're also going to see more executive branch use of essentially obscure provisions that have sat on the books for decades without anyone touching them, used to essentially turn away immigrants, like we saw with the travel ban and with the Remain in Mexico program in the first place. You're essentially forcing the executive branch to dig through all the obscure laws to find statutory authority for something that no one's ever done before because Congress can't actually pass any laws.
And I think the same is true, is that you will continue to see, like, from one administration to another, wild changes and swings in immigration policy. And that's not good for the system either.
Okay, well, on that impassioned call to action, I think we can close. Aaron, thank you so much for coming on. Theresa, great to have you as always. Thank you both. And that's it for our show this week. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Stitcher, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find out more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. I'm Hannah Tyler. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This week's episode was written by Marisol Hernandez, Hannah Tyler, and Theresa Cardinal Brown. Ethan Plotkin produces and edits our show. The executive producer of BPC Podcasts is Lucy Manning. See you in 2 weeks.